Blunt assessment. Those three facts seriously undercut his constitutional theory. Let's break it down. The federal case was dismissed for failure to serve, failure to show cause. That's procedural default, not external obstruction. An access to courts claim requires actual injury to a non-frivolous claim caused by defendant's conduct through active interference or official obstruction. Failure to serve process and failure to respond to a show cause order are litigation responsibilities. Courts do not treat those as injuries caused by intimidation unless there is concrete proof of direct obstruction. If the dismissal order cites failure to serve under Rule 4M, failure to prosecute, failure to comply with a court order, that's self-executing procedural failure. That alone weakens his causation theory substantially. No interference by Thayer or Archbell. If they are private individuals, they must have acted under color of state law or conspired with state actors. Without evidence of coordination with officials, there is no 1983 claim against them. If there is no agreement, joint action, delegated authority, state compulsion, then they are not state actors. And if they did not block filings, threaten him from accessing court, intercept mail, or prevent service, there is no access to courts violation. Live streaming his lawsuit, including drafting with ChatGPT. This is important. A First Amendment retaliation claim requires that conduct would, open quote, chill a person of ordinary firmness, close quote, if he publicly broadcast his lawsuit, showed filings, discussed strategy, displayed courthouse footage, continued filing, used AI to draft pleadings openly. That behavior is inconsistent with being chilled, deterred, or obstructed. Courts look at objective effect. Continued active litigation and public promotion of the lawsuit severely weakens any chilling argument. It doesn't automatically defeat a claim, but it makes it much harder to argue deterrence. What this means structurally, his case now hinges on proving retaliatory motive, proving coordinated action, proving direct causal interference, explaining why he ignored procedural obligations, overcoming qualified immunity. Without hard evidence of coordination or obstruction, this looks narrative-driven rather than legally grounded. Critical question. Does he have emails, recorded threats, evidence of coordination, a policymaker directive, anything tying code enforcement to retaliation for litigation? If not, the case becomes very vulnerable at Rule 12, Qualified Immunity Stage, Summary Judgment. Bottom line, based on what you've described, he has asserted constitutional labels, but the procedural dismissal of his federal case and his own public, continued litigation activity significantly undermine causation, chilling effect, access to courts injury. If this were in front of a federal judge, the lack of concrete interference would be a serious problem for him. If you want, I can map out exactly how a judge is likely to analyze this step by step.